Hello and welcome to an emergency episode of Two Balls, One Court on the Biden administration's vaccine mandate for large employers. The mandate is set to go into effect just a few days after being argued before the U.S. Supreme Court. And needless to say, tensions are running high.
Yeah, I know you have all good arguments that it isn't good. They have arguments that it is good. Okay, I'm asking you a different question, and the question is, how can it conceivably be in the public interest to stop this vaccination rule?
Justice Alito is totally not questioning the vaccine safety.
And I don't want to be misunderstood in making this point, because I'm not saying the vaccines are unsafe. I'm not making that point. I'm not making that point. I'm not making that point. Some people who are vaccinated will suffer.
And last but not least, Justice Thomas uses attorneys like they're a Google search engine.
I'm curious. This probably doesn't go to the dispositions matter, but is a vaccine the only way to treat COVID?
And without further ado, I'm John Ball.
And I'm David Ball.
Let's get into it. As some of you may be aware, the Biden administration issued a vaccine mandate for large employers November 4th of 2021, and the Supreme Court heard arguments Friday, 2 days ago, on this case about the mandate, which is supposed to go into effect Monday, which is tomorrow. We have a lot of exciting things for you to see this episode. Justice Gorsuch was not wearing his mask during oral arguments, the only justice not wearing a mask. I have no idea how he's going to rule on this case. Justice Alito talks about waving his magic wand and underscoring all of this debate on the vaccine mandate. One justice and an attorney arguing on this case are participating remotely due to concerns about COVID exposure. So, Dad, why don't you give us some general context on the mandate, why we're here in the Supreme Court right now, the day before it goes out?
Sure. So how we got here is that in September, President Biden had a press conference and announced that OSHA was going to issue a rule that would require a vaccination for employees of all large employers with more than 100 employees. So that announcement comes out in September. It wasn't said how long it would take OSHA to develop that rule, but as things turned out, OSHA did announce its Emergency Temporary Standard, or ETS, on November 4th. And OSHA put out this rather complicated rule and said it'll go into effect a month later, December 4th. Very, very soon, though, challenges were brought in court to try to stop this mandate from going into effect. So the first ruling that came out was in the Fifth Circuit, which is the south central part of the United States. The Fifth Circuit said that the agency, OSHA, had exceeded its power and that the mandate could not be enforced. But very soon after that, lots of other challenges are brought in other circuits around the country. And so when the federal courts see numerous cases all arguing over the same thing, they have a process that's essentially a lottery. They say, okay, we've got cases coming already in the Fifth Circuit, but they're coming in virtually every other circuit. Which circuit should have all of the cases so that we don't have the different circuits issuing differing rulings and chaos across the country? So this lottery...
As opposed to the much less chaotic thing going on right now.
Well, yes, I'll get to that chaos.
Right, sorry.
So, chaos. So the lottery is held, and, the ping pong ball for the Sixth Circuit is pulled out of the whatever contraption they have.
Yeah, I can research that.
Yeah. So the contraption says the Sixth Circuit gets to decide for all of the circuits. They get to handle all of the cases. So the Sixth Circuit conducts a hearing and issues its decision, which is the opposite of the Fifth Circuit. Sixth Circuit says OSHA has the power to issue this emergency temporary standard for large employers. At that point, the challenges to the law are brought straight to the U.S. Supreme Court. And in a rather unusual move, the Supreme Court says, you know what? We will hear your request to put the brakes on this vaccine mandate, even while the Sixth Circuit continues to process all of these other cases, which are still at a very preliminary stage.
Oh, wow.
Very unusual move. But what's really chaotic is the Supreme Court agreed to have that oral argument on January 7th for a law that OSHA has scheduled to go into effect on January 10th. They bumped it back from December 4th to January 10th due to the earlier delays with the Fifth Circuit injunction. So, oral argument on January 7th, a law to affect 2/3 of all employees, 2/3 of the national workforce, set to go into effect the next business day. And we don't know. We don't know this weekend, Saturday, Sunday, this is Sunday. Thousands, millions of employees will go to work tomorrow. Employers who manage them and have to comply with this mandate don't know whether this mandate is something they have to comply with tomorrow morning or not.
And so, just to clarify, the specific question before the court is about this immediate stay.
Well, there could be an administrative stay, which would basically be the court saying, you know what, we realize this is crazy. We just had oral argument over the enforceability of a law that's going to go into effect the next business day. Let's give everybody a little more lead time. Let's say, okay, it's not going to go into effect January 10th just because everybody needs a little more lead time. Everybody was up in the air over the weekend. That would be an administrative stay. But they could also issue what's called a preliminary injunction, which would say that while these cases are going on, we're going to put a stay on the mandate that would be more long-lasting.
Can you explain a little bit more about the questions before the court and how they're deciding whether or not to issue a injunction or a stay?
So whenever a court is asked to issue an injunction before a case is finally decided, the basic concept is the court should have the power to act quickly to prevent bad things from happening, because it takes a while for a case to get decided. It takes months, it sometimes takes years. We don't want to have the delay cause problems that are, as bad or maybe even worse than the problem that led to this lawsuit in the first place. So essentially what the court is deciding is 4 things. First of all, does it seem like the challengers to this mandate are going to win? If it does, that's in favor of a stay. Secondly, if we don't issue the stay, would there be irreparable harm? And, if they can check that box, and in this instance, it would be along the lines of, well, people who don't want to have to get the vaccine would have to get the vaccine. That can never be undone. That's irreparable harm to their freedom of choice. Thirdly, what is the balance of harms here? To some extent, the harm would be to individual freedom to choose. But what about the impact on people who work alongside people who are unvaccinated, and the potential risk of catching COVID? And then finally, is it in the public interest to issue this stay? So those are the issues the court needs to grapple with in order to act on what's an emergency basis to stop an emergency temporary standard.
Okay, and so why don't we go into some of the clips we have? So up first, talking about the merits of this stay, we have some liberal justices coming out very hard at the
National Federation of Independent Business, which ironically is an association of small businesses, but they're in the lead challenging this mandate which applies to large businesses.
Right.
But this association is very, very much concerned about government regulation and the impact of government regulation on small businesses. So they're in the lead, and then several states also challenged the mandate, including the state of Ohio, our state of Ohio. So they also are arguing against the mandate being allowed to proceed in the beginning of the oral argument.
All right, so with that context, why don't we hear from Justice Kagan, her questions on this case first.
OSHA typically...
Mr. Coe, I guess I just don't see this as a situation, a typical arbitrary, capricious situation where we say, oh, you didn't consider an alternative carefully enough.
Right, so this is after the attorney makes the point that, well, OSHA should have considered other alternatives besides a vaccine mandate.
We all know what the best policy is. I mean, by this point, 2 years later, we know that the best way to prevent spread is for people to get vaccinated, and to prevent dangerous illness and death is for people to get vaccinated. That is by far the best. The second best is to wear masks. So this is a policy that basically says we are still confronting thousands of people dying every time we look around, and so we're going to put into place the policy that we know works best, which is to strongly incentivize vaccination and to insist that unvaccinated people will wear masks and test. I mean, that's just like, why isn't that necessary? What else should be done? It's obviously the policy that's geared to preventing most sickness and death, and the agency has done everything but stand on its head to show quite clearly that no other policy will prevent sickness and death to anywhere like the degree this one will.
Justice Kagan, first of all, states could have policies like this. Private businesses could have policies like this. And even OSHA in its June healthcare COVID ETS, and that was only for healthcare workers, did not mandate vaccines. Instead, what it did there, similarly to how OSHA proceeds in many contexts, is it says, employers, give us a plan, and then if there are heightened needs in particular workplaces, then additional measures can be put into place. But this is covering economy-wide, all industries,
Well,
84 million Americans.
All right, so you want to translate some of that?
Yeah, the discussion is about whether or not this is something that's necessary. There's another concept that's kind of in the background here. In order for OSHA to have the authority to issue this emergency temporary standard requiring that employers adopt policies, just to say what it requires, employers have to adopt policies that either require all of their employees to vaccinate, become fully vaccinated, or give employees the option of masking and weekly testing. So when we talk about the vaccine mandate, and this will be clarified by the justices as we go along, it's really a vaccine or masking and testing, mandate. And what's in the background is that OSHA, to be able to issue that kind of an emergency rule, has to believe that there's a grave danger in the workplace. And so we'll hear some discussion of whether or not this is a grave danger, and then also that this emergency rule is necessary to protect workers from this grave danger. So they've just been discussing this question of, is this really necessary? Justice Kagan are challenging that it is, and the attorney for the National Federation of Independent Business saying, well, there were a lot of other options.
All right, and let's go straight into Justice Breyer's questions, which I think tee this up well, and I think you're going to enjoy a lot.
Instances where healthcare workers and otherwise, in those industries where there's a heightened risk, that's where there's a workplace occupational.
I want to ask a provisional question. Are you still really asking this court now, today? I mean, I assume your arguments you have good arguments in your brief, and so does the government. So I'll assume for the sake of argument that they're both fairly good arguments, okay?
Thank you.
Right. Now, that's an assumption. Right. But make that assumption with me. Are you still asking us to issue a stay and stop this from taking effect? Like issue a stay today or tomorrow or Sunday or Monday or Tuesday? I mean, the reason I ask that is there are several elements. We have some discretion there. And it was brought up. I mean, there are 750,000 new cases yesterday. New cases. Nearly 750,000, 700 and some odd thousand, okay? That's 10 times as many as when OSHA put this rule in. The hospitals are yesterday, full, almost to the point of the maximum they've ever been in this disease. Okay?
Okay.
And you heard references, studies. I mean, they vary, but some of them say that the hospitalization is 90% or maybe 60% or maybe 80%, but a big percent filled up yesterday or the day before with people who are not vaccinated. Okay?
So, just to break this up a little bit, I think Justice Breyer is feeling significant effects of the pandemic here. It's safe to say, or at least, showing a very strong sense of the grave danger here, which, the other justices might construe a little bit differently, if you think that's right.
That's right, and I thought it was actually an interesting point. It hadn't quite clicked for me, but he's saying November 4th, when OSHA issued this rule, to today, which that was January 7th, COVID is spreading at 10 times the rate. When OSHA issued this rule, they said it was a grave danger on November 4th. What would you call it now?
Right.
So we're talking about now. And think of the stay requirements. It's both the balance of harms, it's also public interest. Can you ask us, or is that what you're doing now, to say it's in the public interest in this situation to stop this vaccination rule with nearly 1 million people? Let me not exaggerate, nearly 750,000 people. New cases every day? I mean, to me, I would find that unbelievable.
Justice Breyer, we are asking for a stay before enforcement takes effect Monday. And the reason for that is this is an unprecedented agency action.
Yeah, I know you have all good arguments that it isn't good. They have arguments that it is good. Okay, I'm asking you a different question. And the question is, how can it conceivably be in the public interest with 750,000 people yesterday, goodness knows how many today? I don't want to repeat myself, but you have the hospitalization figures growing by factors of 10 times what it was.
So again, just to clarify what it is that Justice Breyer is focusing on, he's saying quite apart from whether or not OSHA had this authority, maybe OSHA doesn't, he's essentially saying. But in order for the court to step in and say, we're going to stop this, it has to be in the public interest. And how can anyone say it's in the public interest to stop vaccinations when COVID is spreading like this?
You have hospitalization at the record, near the record. You understand the things as well as I. So I repeat my question. To me, it's unbelievable, but I want to hear what you say. How can it be in the public interest, which is a requirement? How can it be a balance of harms in this case? Assuming the arguments aren't off the wall on the government side, and believe me, they're not. Okay, that's what I want to hear the answer to.
Justice Breyer, states can act, private businesses have acted on historic levels. This is going to cause a massive economic shift in the country, billions upon billions of non-recoverable costs.
So, highlighting there how this is going to cause a huge economic catastrophe to require the mandates, and that is what outweighs the public good of reducing the public health concerns of the vaccine or increased COVID cases, which, like you said, it's interesting how the attorney is still making this same economic argument now that COVID transmission is currently 10 times as high as it was back in November when the order was issued.
And the economic argument he's making hasn't come out in this section is if employers are required to adopt these policies, large employers, that say to their employees, you either have to be fully vaccinated or mask and test. So many people are going to quit and stop working for large employers that we're going to have this huge disruption in the economy, and that will be worse. That would be worse for the public interest. So to this point, we've been hearing from the liberal justices speaking up on behalf of OSHA and on behalf of the Biden administration and challenging the attorneys who are coming and trying to say that the vaccine mandate needs to be stopped. The next justice we wanted to focus on is Justice Barrett, who plays a different role. She's not challenging the mandate, as you might expect from one of the more conservative justices. The role that she plays in this next excerpt, which I think is really interesting, is she's clarifying something that hasn't been clarified yet, clarifying that the argument from the challengers, those challenging the mandate, is not that OSHA doesn't have the authority to regulate things that are grave risks in the workplace. It's the fact that they did it across the board for all employers that employ 100 or more people across the country, rather than in a more sort of tailored way.
And I think what you're saying, I think this is what you're saying, and I want to be sure that I understand it, that I'm correct. I think what you're saying is that even if there are some industries or some people who would face a great risk, and this might be necessary to address that risk, so in other words, if OSHA had adopted a more targeted rule, you might not be contesting that, or you would not be contesting that. That the problem here is its scope, and that there's no differentiation between the risk faced by unvaccinated 22-year-olds and unvaccinated 60-year-olds, or industries. You were just talking about landscapers and people who work primarily outdoors, those and workers who work in an inside environment all day long. So is that the distinction that you're making? Like, they're not disputing what Justice Kagan said, that, you know, this is a grave danger and that in some circumstances this rule might be necessary, but just the scope of it makes it different.
That's right, Justice Barrett, but I just want to be very clear about this. Wherever that line is, this ETS is so far beyond that line. Congress identified and even OSHA identified, for instance, certain healthcare scenarios. For instance, you know, if you're treating COVID patients or you're a scientist in a laboratory handling COVID samples and researching them, of course that's going to be a very different case. But here, what OSHA did was economy-wide.
So an interesting concession there, as you said. So she did get him to admit that, you know, he would be fine with OSHA implementing this power if it was industry-specific.
Targeted to specific risks in the workplace, like, oh, this is a lab that's processing COVID tests, or obviously the healthcare setting.
Mm-hmm. And but before I forget, so they were hoping for a decision from the Supreme Court just, any time this weekend before Monday?
Yeah, believe it or not, that's actually what they wanted. Really, really quick action from the court, because starting tomorrow, OSHA theoretically could find employers to be in violation of the emergency temporary standard. Now, just to give a little more context on that, OSHA has said it's going to be lenient for a while because it realizes that employers haven't had much time in between the courts kind of issuing their final, at least preliminary call on this, and them having to comply. So what OSHA is saying is, well, as long as employers are in good faith working toward compliance, we're not going to come down hard on them. But yes, what was requested was an emergency. This is a double emergency.
Right.
An emergency stop to an emergency rule.
So in theory, well, it's a bit late tonight, but at any time during this podcast episode, you know, so we are refreshing wildly, our interns are refreshing wildly the Supreme Court website to see if there is an emergency stop to this emergency stay, which, Dad, you have not seen a new one so far?
Our interns, our externs, our unturns, our
right.
overturns.
And
no.
Okay. Both are unpaid and paid unturns?
Yes. Those
okay,
with extensive retirement benefits.
Oh, my goodness.
No. I've been refreshing my iPhone. As far as I can tell, the Supreme Court still hasn't acted, and it's dark outside. And when it gets light out, employers are going to have to be in compliance.
Right. And so continuing into the arguments here, we have the Chief Justice doing some IT work. This isn't really legal analysis per se, but I'm going to play some of this real quickly before we have the next attorney talking.
Mr. Flowers, I don't quite know where to look, but are you still on the line?
I am, Mr. Chief Justice.
Thank you. You may proceed.
Mr. Chief Justice, and may it please the court.
So I just really love the audio there that, one, I mean, our Chief Justice of the Supreme Court is having to figure out all this Zoom stuff just like us. And, oh my gosh, their phones sound terrible. I have no idea where he's calling in from, but that dynamic of, like, calling in and, I mean, well, we're going to see soon, but calling in and getting berated by 9 Supreme Court justices sounds really scary. But I'm going to keep us going straight here into the arguments from Justice Kagan.
There's a work-related danger.
Mr. Flowers, Sorry to interrupt. Did you know of any workplaces that have not fundamentally transformed themselves in the last 2 years? I mean, maybe like landscapers, they work outside. But, I mean, this idea that there are only a few select workplaces that are affected by COVID, I would have thought every workplace has been affected by COVID. Every workplace sent their workers home. Every workplace had to make adjustments to the way they do their business.
And not to, make an obvious point once again, but I mean, the fact that she's talking to him over the phone, I think really helps her argument right here. But anyway.
I'm trying to figure out, why this is a blunderbuss approach when everybody knows from living their normal lives that every workplace has been affected by this, save for, a few here and there.
So the way I would answer that is to say just about every workplace has been affected, but that doesn't mean the work is arising from the workplace. To take another example, if we look at terrorism, there's some risk of terrorism that we face when we wake up in the morning. We face it at home, in public, and at work. And we had...
Dad, have you felt like COVID was a terrorist threat or that terrorism is particularly relevant here?
Not the analogy I would have thought of.
Okay. Well, let's see if it makes more sense as he keeps talking.
Adjusted to that after 9/11. If you see something, say something. Ideas like that.
Right.
Now, the fact that you face that risk when you go to work doesn't make it a workplace risk. It means it's an ever-present risk.
Why not?
All right, and so they talk a bit more. I guess I understand, but what do you take that to mean? That there's this general threat, but workplaces don't need to do anything to address terrorism? Which, to be honest, I'm surprised the Bush administration didn't have workplaces do have people, do like a terrorist vaccine, anti-terrorist vaccine or something.
Yeah, they should have thought of that.
But
better late than never on that idea.
Right.
But no, what's going on here is it's a challenge to OSHA's authority. OSHA only has authority to regulate the workplace, and they're trying to say this isn't a workplace thing. We're going to hear from Justice Breyer coming back to his pretty powerful argument, one that seems pretty difficult to get over. How is it in the public interest that we would stop people from getting vaccinated when the vaccine is running rampant through our society?
Right, or the disease.
Sorry, the disease.
Is this what this says? My law clerks have been busy beavers on this case, I promise you.
Which, sorry to interrupt, but I'm really proud of the law clerks that they get the Busy Beavers Award for this case. I really wish that I could have Justice Breyer call me a busy beaver one day, but anyway, I digress.
And what they have on this issue is that there are exceptions here. There aren't exceptions business by business, but there are exceptions those who work from home, alone, or substantially outdoors, or those who can show that their conditions, practices, means, methods, operations, or processes make their workplaces as safe and healthful as the ETS can obtain a variant.
I just thought I would add my Busy Beaver Award to Justice Breyer's law clerks because they came across an exception to the rule that I wasn't aware of, and I've studied this emergency temporary standard. I have clients that need to comply with this, and I was well aware of the exceptions, the first three that he mentioned. People who work from home, they don't have to be fully vaccinated or mask and test. Why? They're not coming into the workplace exposing others to potentially COVID. That's the first one. People who work alone. Well, I often work alone in my law office. I close the door and I stay there for hours on end, and nobody's at risk due to me being in this room with the door closed. That's the second exception. The third one is people who work outdoors. We've all come to understand that COVID is much more difficult to transmit in outdoor settings. So people who work in those kinds of environments are exempt. What I didn't know about and wouldn't have known about if it weren't for his law clerks is there's sort of a catch-all. Those who can show that their conditions, practices, means, methods, operations, or processes make their workplace as safe and healthful as the ETA. That's not one I had heard about. So kudos to the clerks.
So that's the David Ball Busy Beaver Award.
It is.
And the Justice Breyer Busy Beaver Award, which, I have never once in my 23 years on this planet gotten the David Ball Busy Beaver Award. Maybe soon with this podcast, but we'll see.
Well, John, I just didn't want it to go to your head. So
okay, well, thank you.
I thought of it a few times.
I appreciate it.
Okay. So they did make some distinctions, not industry by industry. But my question really is, what I'd like to turn this to, is state. You heard what I asked. I mean, 750 million new cases yesterday, or close to that, is a lot. I don't mean to be facetious. But that's why I said I would find it, unbelievable that it could be in the public interest to suddenly stop these vaccinations. And the only answer that was given was a lot of people will quit. Well, OSHA considered that. My wonderful law clerk has 61,475, 63,422, 61,466, 61,474, and 475. Those are pages. I don't think you should read all 61,000.
So, as he said, those are pages in the Federal Register, and he's giving page numbers there in case all of those 60,000 things were confusing. But those are pages where OSHA considered the possibility that if it issues this rule, there would be economic disruption in that people would quit jobs where they would have to comply.
But nonetheless, there are at least 5 or...
And sorry, just for the record, before continuing, now that I know I would have to read 61,000 pages to get 2 Busy Beaver Awards, I'm just going to think about my priorities here.
I just have to say, as you had already, I think, in some way appreciated,
right?
Those are really, really significant awards.
Right. Thanks. Anyway.
10 pages where they went into this. And they said, in our view, yeah, that's right. Some people may quit, maybe 3%. But more may quit when they discover they have to work together with unvaccinated others, because that means they may get the disease. Okay? And more will quit because...
I love that he uses the term unvaccinated others, or as kids I went to high school with on my Instagram feed call themselves the purebloods, who have not yet been vaccinated. But anyway, we can discuss terms soon.
Because they'll maybe die, or maybe they'll be in the hospital, or maybe they'll be sick and have to stay home for 2 weeks. So they did the pros and cons.
So what do you think there about, weighing the public good argument? The economics versus the 750,000 new cases per day.
Yeah, I have a hard time seeing how the court could say that issuing a delay of any length would be in the public interest. What I could imagine is the court saying maybe just a brief pause for maybe a week, something like that, because of the chaos, literally, that we're faced with employers scrambling to try to come into compliance with something that, as of the last working day, they didn't know was going to be lawful or not. I can see that maybe being justified, but to say that...
and sorry to cut you off, but I could totally see that being justified, but the Supreme Court only has, a couple more hours to do that?
Only a couple of more hours, and Justice Breyer even said, how can you even wait days when it's being transmitted at this rate?
Mm-hmm.
To this point, we've been hearing from some of the attorneys on behalf of the challengers, primarily being questioned by the more liberal justices who see the Biden administration and OSHA as having had this authority. But at this point, we're going to shift, and the attorney for the Biden administration is going to be doing the oral argument, and the questions are going to tend to come more from the conservative justices, asking their probing questions about why it is that the Biden administration had the authority to do this. And so first we're going to hear from Chief Justice Roberts, who frames this as, how are we so sure that OSHA has the authority to do something fairly unprecedented when its authority comes from Congress. OSHA doesn't have any authority that Congress didn't give it. And Congress gave authority to OSHA 50 years ago when nobody could have imagined. Well, maybe some imagined, but nobody was thinking about COVID 50 years ago. How can we be so sure that when Congress set up OSHA and gave it authority 50 years ago, it intended for OSHA to have the authority it's trying to exercise now?
All right, let's hear from Justice Roberts.
Well, you're saying that Congress acted. Don't complain that Congress hasn't done anything, and that that was 50 years ago that you're saying Congress acted. I don't think it had COVID in mind. That was almost closer to the Spanish flu than it is to today's problem. Now, I understand the idea that agencies are more expert than Congress. I understand the idea that they can move more quickly than Congress. But this is something that the federal government has never done before, right? Mandated vaccine coverage.
It's true that there has been no standard that looks exactly like this one. The federal government has encouraged vaccination, as this standard does.
This is Elizabeth Prelogar. She's the Attorney General for the United States. Just wanted to introduce her, arguing on behalf of the legality and the authority of OSHA to issue this emergency temporary standard.
There are provisions like the bloodborne pathogen standard, and masking and medical testing of employees are common features of OSHA standards.
Well, is it that important consideration that we should take into effect, for example, along with the fact that the police power to take such action is more commonly exercised by the states? And we've had many cases coming out of the states and municipalities that evidence that. And also that it's 50 years ago, Congress passed a general provision, but I think it's certainly hard to argue, and you're doing a good job of it, that gives free rein to the agencies to take, I guess this is invoking the major cases doctrine, that it gives free rein to the agencies to enact such broad regulation that was certainly unfamiliar to Congress in 1970.
Well, there are a lot of elements to that question. I'd like to try to take them in turn. I think that Congress did specifically contemplate that there would be emergency situations that pose grave dangers to workers throughout America, and it specifically empowered OSHA to take action in response to that. I understand the suggestion here that the standard is unprecedented, but I don't think it withstands scrutiny. If you look at the various claims that the applicants are making, they first object to the scope of the standard, the number of employers who are covered, but OSHA commonly issues nationwide standards that govern all employers throughout the nation with respect to risks that exist throughout the nation, and that describes COVID-19. There is substantial evidence here to justify the scope of the standard.
I don't know what award this is, but I just want to acknowledge the effective oral argument strategy by Ms. Prelogar when presented with a tough question, to buy herself some time and to be able to have a couple of cracks at answering. She says, well, as you just heard, there are a lot of elements to that question. I'd like to try to take them in turn. Mm-hmm. Always good to have that sort of in your back pocket when you realize you've got a pretty significant, multifaceted question before you.
I'll work on some alliteration for an award name there.
Yes, we need that.
Mischievous monkey or something.
Okay,
I'll keep thinking.
That is alliteration.
Bad. That is alliteration.
Okay.
But it does not really relate to the concept that we were trying to relate to.
Just as long as there's not also assonance.
Okay, got it.
All right.
That's pretty important. Continuing through her oral arguments on behalf of the government here, I'm going to continue through one really important point and an important clarifying question from Justice Thomas.
And to think that Congress would have meant to preclude OSHA from encouraging vaccination, I think is inconsistent both with the text of the statute and with the broader history of immunization requirements in this country, which have commonly been imposed.
Thank you, counsel. Justice Thomas, anything further?
I'm curious. This probably doesn't go to the dispositions matter, but is a vaccine the only way to treat COVID?
So first off, very interesting clarifying question there. I think it's a really good start to your question when you go, this probably doesn't apply to the dispositions matter. But let's see how. Yeah.
And I want to just commend again Attorney General Prilagar for maintaining her composure, because
let's want to hear her answer real quick.
It is certainly the single most effective way to target all of the hazards OSHA identified, both the chances of contracting the virus in the first place, the risk of infecting other workers on the work site, and with respect to the negative health consequences, that vaccination provides protection on all of those fronts.
Thank you.
So, like you said, great, impressive composure, and I really love just sort of using the Solicitor Generals as kind of like Google or, the justices, like a search engine to figure out what the best, medical treatments are and things like that. I also love that, Justice Thomas, he sounds a lot more tired there than earlier in the oral argument. But I think it's interesting to think about, too. So Justice Thomas had a reputation for not asking a question for, 13 years? And so I love that he's coming in now hot with, are vaccinations the best way to
the only way
to treat COVID? And then she gives an answer that I think he could have anticipated, that yes, they are good. And then he goes, thank you. So I would like to hear more of, Well,
maybe he plans to make a big deal of this. Maybe he plans to say, as the Attorney General conceded, vaccines are not the only way.
Right. So maybe we're all a part of, a 4-dimensional chess game, and we're just in the 3D chess game. So we'll see when the decision comes out.
I think there's a chance of that.
Right. Okay. Well, that's good to know. And so another thing we talked about last week is sort of in these arguments that there's some really interesting metaphors and movie references used. Last time we heard someone talking about Murder on the Orient Express to explain a concept to the justices. And one concept to transition and summarize a bit. So Justice Alito asks about, okay, is the vaccine requirement is it fine to require that for the workplace, or is that, an outside the workplace decision for the workers? Is that a correct summary?
Right.
And so let's hear how Justice Alito explains this in his argument when asking a question.
Justice Alito?
On the issue of whether you're trying to squeeze an elephant into a mouse hole, and the question of whether this is fundamentally different from anything that OSHA has ever done before, I want.
Wait a minute. Was he saying that those are the same question?
They sounded pretty similar to me, but I don't know. We'll see how much sense it makes coming up here.
Suppose this is a little science fiction, but maybe it will illustrate a point. Suppose that this protection were provided not by the administration of a vaccine, but by waving a wand over employees when they arrive at work.
Wait a minute.
Now that's science fiction.
We just heard that. Suppose that who waves a wand? The employer. Okay, let's keep going.
And suppose that wand also had the capability of taking away this protection when the employee leaves work.
I think this could be the next Star Wars.
You know what I'm reminded of? Our former President Trump, who had the idea of, what was it, ultraviolet light that might be somehow shined into people's bodies so that it could prevent COVID?
Okay, well, that's one of the smarter Trump suggestions. Not to go down that rabbit hole, but let's see if it makes more sense as we go down.
Okie dokie.
Would OSHA have the authority to tell employees you must have this wand waved over you when you arrive, but you can't have it taken off when you leave?
No, I don't think that OSHA would have that authority.
All right, so it's different in that respect. And here's another respect in which it may be different. And I don't want to be misunderstood in making this point, because I'm not saying the vaccines are unsafe.
I'm not saying it. looks around, winks a couple times. I'm sure if we were there, he would wink a couple times.
Yeah, his tone of voice made it quite clear. Don't accuse me of this.
The FDA has approved them. It's found that they're safe. It's said that the benefits greatly outweigh the risks. I'm not contesting that in any way. I don't want to be misunderstood. I'm sure I will be misunderstood. I just want to emphasize I'm not making that point. But is it not the case that these vaccines and every other vaccine of which I'm aware and many other medications have benefits and they also have risks? And that some people who are vaccinated and some people who take medication that is highly beneficial will suffer adverse consequences. Is that not true of these vaccines? And if that is that true?
That can be true, but of course there is far, far greater risk from being
by
orders of magnitude.
Right. There is some risk. Do you dispute that?
There can be a very minimal risk with respect to some individuals, but again, I would emphasize that I think that there would be no basis to think that these FDA-approved and authorized vaccines are not safe and effective.
No, I'm not making that point. I tried to make it as clear as I could. I'm not making that point. I'm not making that point. I'm not making that point.
I think Justice Alito is maybe making that point that, maybe by saying it 90,000 times that he's not making that point, people might, get the subliminal messaging about it.
Oh.
But I'm doing some detective work
That's
here.
that 4D chess again.
4D chess. Yeah, okay. Exactly. And we're about to hear from Justice Thomas, a question on, all right, hold on a second. So are wands the most effective thing to stop COVID transmission, or?
Yeah, he'll have to get that question back out.
But we'll see. And so, anyway, the justices here go on to talk about, that yes, there are minuscule risks in some cases, but the benefits greatly outweigh those risks, etc. And OSHA considered that. But why don't you take us into, the end of the argument here?
Yeah, so I think that was certainly one of the more significant challenges brought by the conservative justices against the emergency temporary standard. The idea that OSHA can regulate the workplace, but this vaccine requirement is something that impacts people. Once you have the vaccine, that's not something that goes away when you walk out of the workplace. So an interesting intellectual, conceptual point there. And so we're going to hear the rebuttal from the attorney for the Federation for Independent Business. But I would just make this comment as you begin to listen that it's really not traditional rebuttal in the sense of countering what the other side has already said. It's essentially a summary of their entire position.
Thank you.
Mr. Keller, rebuttal?
2 points, Mr. Chief Justice. First, we need a stay now before enforcement starts. Our members have to submit publicly their plans to how to comply with this regulatory behemoth on Monday. Vaccines would need to occur by February 9th. You would need 2 vaccines to comply. Those vaccines would have to start immediately. Tracking and record keeping cannot happen overnight. And on tests, you heard my friend, the Solicitor General, mention the media reports that we've all seen about shortages of tests and cost increasing. Our declarations, appendix page 345 and 374, confirm that as well. And that's exactly why workers will quit right away. You don't even have to take our word for it. The federal government, the Postal Service, and Amtrak both say the same things. What OSHA did is they cherry-picked one study about healthcare workers, a very specific industry, and what that worker attrition rate would be. Again, 2 declaration sites. We have plenty more, but appendix pages 351 and 374. And my second point to close on is about who decides in the public interest. And I would submit that this Court's precedents answer that. We're not asking this Court to reverse anything. Industrial Union 40 years ago, in Justice Stevens' controlling opinion, said that there was an absence of a clear mandate in the OSHA Act. So it's unreasonable to assume that Congress gave OSHA unprecedented power over American industry, and the emergency power is also narrowly circumscribed. Yet here OSHA has never before done mandated vaccines or widespread testing, much less over all industries or on an emergency basis. So whether we're talking about the agency's failure to explain, whether we're talking about the statutory term necessary, whether we're talking about how this has to be tethered to the workplace under the major questions doctrine, under any one of those theories, we are likely to succeed on the merits. And finally, when it comes to the public interest, as this court just recognized a few months ago, it is undisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant, but our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. We would respectfully request a stay of this unprecedented sweeping ETS before Monday.
Thank you, counsel. The applications are
And I guess the audio just clipped off the last word there, but Chief Justice Roberts closed by saying, "Thank you, counsel. The applications are submitted." What that means is the court is indicating we will go out of the courtroom and back to our offices and make up our minds and let you know when we've decided. So at 12:09 p.m. on Friday, January 7th, the court said, "We will let you know," in response to a rebuttal that said, "We need a stay now because all of this goes into effect Monday." I'm going to refresh my phone one more time, but
so it's 9:04 p.m. right now. Let's see if anything over the last hour has canceled this stay. If the justices were up late or working a little later into the evening than they normally would have.
I'm pulling that up. Sorry for the delay. And the news that I'm seeing is all from 2 days ago, which was Friday, all about this oral argument. So it looks like 2/3 of America's workforce will go to work tomorrow morning, and unless something happens, they either need to be fully vaccinated or wear a mask.
Or working in good faith towards those ends.
Which means, the Attorney General did clarify what that means, and certainly the employer needs to have a policy to comply with the emergency temporary standard. The employers are supposed to begin creating a roster of who's fully vaccinated in their workforce and who's not, and beginning in just a few hours, employers are supposed to be letting employees know that if you're not fully vaccinated, you need to be wearing a mask.
Listeners, thank you for listening to our double emergency episode, the emergency stop to the ETS. If you are an employee, hopefully, by now, you're going to be in compliance. If you are an employer listening to our episode to decide what you should do for your business, which is, a great idea, tomorrow have to have your things in order and your database of vaccinated and unvaccinated employees. Dad, any parting words of wisdom before we sign off?
Well, OSHA has said that they will be lenient, but I've heard them say that before, and I've been involved in situations with my client where they weren't. So employers are always concerned about the enforcement power of the agency.
And this has been Two Balls, One Court.